Friday, and we're looking at H108. You can hear from Legislative Council. Over to you, John. Nice to see you.
Nice to see you.
Thank you for being here.
Yeah, good afternoon. For the record, Michelle Towns, Office of Legislative Counsel. So we're taking up H108. And I will just start out by saying, when I got the draft request, I had to look up a definition of filial. Somebody asked me for the draft for the bill, and I was like, I don't know what that word means. And so if you're surprised that there is a legal requirement subject to a criminal penalty for not supporting your elderly parents financially, if you are able to do so, count me in that category of surprise as well. Until I started looking at this statute. The first thing I did was actually call Robin Arnell over there. And I see she's on your witness list for today. So when I first started here in the 90s and working on child support, I worked with Robin at OCS. And so I called over to OCS and asked, I was like, do you guys know anything about this? Well, the short story is like, I didn't really find anybody who really had any familiarity with this provision in the statutes. It is kind of buried deep in the, in the family law around non-support tied to child support, which is what we do enforce and work on. But I decided, well, let's go back and kind of see where this came from. I could guess, thinking about it, but so this idea originated with, and I'm going to tell you the name of the act, the Elizabethan Poor Relief Act of 1601 in England. And, the idea behind it was that family members should be financially responsible for the members of their family. And otherwise those people would become the responsibility of the state, meaning whether it's the local government or whatever. So when you had the colonies, that was kind of exported to the colonies, some form of that. I did a little digging, and with the help of Michael Chernick, as best we can tell, Vermont's first law on this was enacted in 1890. So a person who 1890.
Thank you.
A person who, being of sufficient ability, neglects or refuses to provide necessary food and maintenance for his wife or minor children, being notified to do so by the overseer of the poor, shall have be fined not more than $20. That was 1890.
That's a lot.
Then in 1902. They started to get a little tougher on that, and they added that it could be the $20 or imprisonment for not more than 6 months, or both. And then added that a married woman, for these purposes, would be considered a competent witness, because back then you had to clarify that, right? So that was added in 1902. In 1915, they moved that 6 months up to 2 years of hard labor. And that if the court imposed the fine, then that fine should be paid in whole or in part to the wife or the guardian of the child, if there isn't a wife.
Okay.
Just curious. Back then, the child at any age?
Well, that is interesting because in 1915, they added that it was a child of 16 or under. Before that, there wasn't any distinction on the age. Although actually, did they say they probably said a minor child? Minor child. So it would be generally considered under 18. I don't know.
Major children too.
Right. And then they say 16.
17, 18, and 19-year-olds are the major child.
Then in 1921, they added stepchild. And then in 1925, is when they added the parent. So 1925,
Fine.
okay, where they added, or any adult, oh, you just missed the good stuff.
Do it again.
You'll have to watch the tape.
I will.
Um,
Always good.
so in 1925, they added the adult provision. So, or any adult possessed of sufficient pecuniary or physical ability to support his parent, or who unreasonably neglects or refuses to provide such support when the parent is destitute, unable to support himself, and is a resident of the state. So 1925.
Is that when they put the 2 years in there too, or no? No.
So the 2 years was added in,
That was hard labor though. We had work-
first,
had work.
first it was the 6 months in 1901, and then, no, 1902 was 6 months, then 1915 was 2 years of hard labor. Then the parents in 1925. And then, the next changes weren't until 1973. And I will note for you that, so you think the parental piece was added in 1925. In 1935 is when you had the Social Security Act. 1965, you had Medicare and Medicaid, right? So you have you have these big laws around social safety nets that are coming in and really changing the picture. And what you started to see was it used to be that all states had some version of these types of laws, not necessarily criminal penalties. I mean, I think it used to be more criminal penalties, but then evolved over the years. So so there weren't any changes to the statute from 25 until 1973. And there were just some language changes. There's also the change that used to be very gender focused. So a husband, wife, children, right? So changes in 1973, a married person who fails to support their spouse. So
That's impressive.
taking out the gender aspect, and also got rid of the hard labor requirement because we no longer did that. Then in 2010, and I remember working on this with Robin, OCS came in and asked for authorization to be able to enforce this section because it's a criminal statute. It's, enforced by the state's attorneys or arguably by the Attorney General's office. And so they had asked for authority to also be able to prosecute these cases. So that was legislation that passed in 2010. And then we got our law here. So if we turn to the language of the bill, you'll just see section 202. So penalty for desertion or non-support, a married person who without just cause deserts or willfully neglects or refuses to provide for support and maintenance of spouse or children. And then you'll see starting on line 17 and continuing is just striking the obligation around supporting parents. There are, as best I could tell, I didn't do a exhaustive search there, but I think there's about 30 states that still have some kind of version of this, but, they are not really enforced. Most don't have criminal penalties associated with it. It's more of like an obligation around civil cases, things like that. I didn't go too much into that because it's not what you have before you, but there is an interesting history with all of these laws, but they generally seem to be not utilized as applied to support of the parents.
Questions for Michelle? Well,
I don't even know where to start.
are those questions for Michelle or are there other ways?
Exactly.
Or just for discussion?
I was gonna say that exact same thing.
Yeah.
Well, yeah, no, go ahead.
Okay, please.
I can't breeze in here 5 minutes late. That's the
That's
first
true.
question.
Yeah,
No.
Everybody gets priority over the late.
I'm surprised that it exists in mostly, I know Office of Child Support where they would have some vested interest in this, but if you don't in the child support realm, for instance, if you're not paying long enough, you end up there's not a criminal penalty, but you can be civilly confined.
It can be,
But it's not under this statute, correct? I mean, it's something different. It's,
Right, and I think when you talk to OCS, they can talk to you about the whole, how it's done now, and I don't think, that they even really use this in the support of children, like in terms of the criminal penalties any longer. There was a time there, probably in like the mid-aughts, where that we were doing a lot of child support legislation and kind of tweaks based on federal requirements. And was that like when the driver's license suspension stuff came in and things?
Yeah, that was in the.
Right.
Yeah.
So there was a lot of action around that, and the idea being that, like the reason why you have the structures that you do, like around child support, is so that you don't have families who are on public assistance and the state is paying for families when you don't have the parents supporting the children and the families. And so there are a lot of strategies in existing law on the civil end in terms of support obligations. And this proposal is not suggesting that you remove this criminal statute as it applies to support for children. It's just striking the provision as it applies to supporting parents.
good. Ian,
When this was brought up in 2010,
Mhm.
was there any discussion in striking this?
Like I said, I wrote that amendment in 2010 and I don't even remember that parent part. I don't think so.
Okay. This seems like it would have been archaic in 2010, as
Yes.
archaic as it is now. And so I
Yes.
just wanted to confirm there wasn't any discussion. then.
No, I will say, and you'll learn this the longer you're here, which is that oftentimes we'll come across old language, archaic language. For me as a staffer, it's so painful for me to not update it and to change it and to get rid of all the old timey language and stuff we don't say anymore and stuff. But oftentimes people say, yeah, but we've been working with that law for so long. Now's not the time. Or then we'd have to bring in all these people to make sure that we don't, unintentionally harm it in some way or do something. And witnesses will come before and say, right now, we just need you to do this because we got a problem here. And then everybody just kind of kicks the can down the road to kind of go through and do some kind of cleaning up of the statutes. Last year, for those of you who were here last year, you might remember when we did some tweaks to the parentage laws. Also, OCS came in and asked for just some technical amendments. And you remember we finally got rid of that statute, man in the house.
Yeah.
That was like something I had been begging people to get rid of ever since I was here and had noticed that. And finally, and the answer always was like, we don't think we use it, but we're not ready to quite get rid of it yet. And so finally got rid of man in the house last year. But now apparently the time has come for getting rid of parents in the house.
so there's also times where we like to leave things in kind of as relics, like I'm looking at 9 VSA section 2574, one of my favorites, destroying butter crates, that $5 penalty. So 50 cents for each receptacle so defiled. But we're not going to get rid of that. We've got to keep that one. And painting horses too. I don't remember where that one is.
I will say, I could not find
We need
any
to go.
case law related to this with parental support.
That was my question.
No, I couldn't find anything.
Do you know the last time it was enforced?
I literally could find nothing.
Oh.
This is like the fact that I just brought you that this was like for me to make up something to talk about because I didn't have anything to talk about. I didn't have anything to talk about how the courts had interpreted it, like nothing. It would be like, well, it started with the Elizabethan Poor Act of 1601.
Which is like, it's funny because it's like I had taught like social work history and it fits in.
Mhm.
So those, can you go give those to Nate so we can put them online as well? 'Cause-
All the laws?
Yeah, those, yeah. Is that okay?
Sure.
Come on,
Yeah,
part of our record.
absolutely. I
Yeah.
mean, I could do a little outline that says what was changed or no, just give you the old laws?
Yeah, I don't
Okay.
you didn't have to do that.
Okay,
We'll just scan them and put them on.
sure.
Fine. So other questions for Michelle? Not seeing any, we'll go to Judge Zone, who's joining us from somewhere else that's not here.
From the home office today.
All right, excellent.
Good afternoon, Tom Zone, Chief Superior Judge. So this issue, this bill, I checked from 2010 until now, there have been 3 counts brought of a violation of 15 VSA Section 202. They were brought against a single defendant as part of a 12-count case, and they were dismissed along with 10 other counts, and they were all dismissed except one charge that the individual pled guilty to for cruelty to a child that did not relate to the child support. And so, other than that, in the past 15 years, there have been no prosecutions under this. I can tell you, though, that before 2010, when we have those records, I recall presiding over a trial in Rutland for willful failure to pay child support under 202. That's, if my memory serves me correct, that's the statute. So this is not a statute that is used. It is certainly a policy that the legislature can adopt to eliminate the parents. The impact on the courts, it's not going to take much away because, again, it's not used. I do note that the statute even utilized for a parent who doesn't pay child support for their child is limited to married parents. In other words, if you're not a married couple and you are an unmarried couple and you don't pay and you willfully neglect to pay child support, this statute does not apply. There is a federal statute that can be implemented for willful failure to pay child support. There's the feds do consider that, I guess, but again, this is not a statute that's used very much in Vermont policy decision, and it will not have much of an impact. The federal statute is 18 USC section 228.
Okay. Any questions for Judge Zone? I think that was fairly straightforward. That's what we wanted to understand. So really appreciate that.
My pleasure.
All right, thank you, and have a great weekend. Well, were you waving goodbye, or were you raising your hand, Tom?
No, I was waving goodbye.
All right, okay, all right, fair enough. We'll see you next week, I think, on something, if I'm not
Yes,
mistaken.
I have already, we've been in touch with Nate, and so yes, we are committed to be there a few days next week. Look forward to it.
Great, thank you very much.
Thank you. Have a great weekend, everyone. Take care.
Great, excellent. So we will call whoever wants to talk to us from OCS. Is it Robin, or is it both, or just?
Well, if I get stuck, I will bring in my copy.
All right, fair enough. Fair enough.
The old phone a friend.
So, good afternoon.
If you could identify yourself.
Yes, for the
please.
record, I am Robin Arnell, a Deputy Director for the Office of Child Support. I guess I'll start out by saying, agreeing with Michelle and admit that, admittedly, I don't go to the statute very often. I think we had one case that we prosecuted, but I completely read over that language. When she called me or emailed me back a couple of months ago, I was like, where is that? I've never seen it before. I just overlooked it. And I also want to say that as a program, it's state administered, but substantially federally funded, the child support program, that isn't even part of what we would be permitted to do anyway. The federal government prescribes, it has a directive about the different requirements that our program will, that we're permitted or required to do, and that is not one of them. So, bottom line up front, we have no objection. the committee legislature deems that this should be repealed. And in fact, as the judge said, we actually had one criminal prosecution that we did internally within our office, probably right after the statute was amended. But what we found is these criminal statutes, they're a lot of work. They take a lot of resources. They're not particularly effective. And our program has evolved quite a bit since the 90s. It used to be very heavily focused on, very punitive, recovery oriented. We thankfully have evolved to the point where we're looking at the case holistically. We're looking at both parents. We're looking at whether someone has the ability to pay or inability to pay. And we take from the various remedies that we have civilly, and we, choose the appropriate tool for the job. We have a lot of different tools, thankfully, that have been passed and enacted over the years. And if we put this on an arc, with, wage withholding on one side and contempt, civil contempt on the other, we feel that we have the appropriate statutes to, make sure that children are getting the support that they deserve.
So I can open up I have a couple questions, but I'll open up first, Angela.
So, hello.
Hi.
So it sounds like we don't need any of those statutes.
We're not using it right now. And I don't know if ever, but I don't know if the state's attorneys, it sounds like the state's attorneys, this is not judging from what Judge Zone just testified to.
And in fact, if I understood you correctly, even if you wanted to use this statute, you would not be permitted to because of the federal guidelines that.
With respect to the filial,
Okay, that's
pursuing parents.
Okay.
Yeah. Sorry, should have been more specific about that.
Gotcha. Okay. Thanks.
Other questions, Tom?
Well, the only thing we haven't addressed would be then the married couple leaving one spouse. And then,
Yeah, I was gonna ask if we should just strike the word married, does that? I mean, it broadens it, but it seems a little odd to have something just, given what we've been doing with parentage and all these other things.
I get what you're saying, but then who is the obligation to? And how are you going to
So-
identify that in terms of, like, if it's not, so this covers, so let's say there were not any children involved. There's this criminal statute for support of the spouse, right? I don't know how, if you get rid of, I mean, you're just saying you would get rid of that
I
part,
see,
you just
I
have to
see.
apply to children?
I
Is that
see.
what you're saying in general? Or you
No,
would get rid
no.
of the married status, but.
It's the marriage, yeah, okay, the person's spouse.
So that just felt like a.
Yeah, that's
a
bigger.
whole,
That's a whole.
other thing?
Yeah, no,
you
I
could
got
get
it.
rid of the obligation that the spouse, partner, whoever it is, and just apply it to minor children. If you wanted to leave it there, or you could get rid of it altogether.
I say we just stick with what's in the bill itself and not go down that rabbit hole if we don't need to.
But I get what you're saying, you
Yeah,
know,
yeah, but
about
no.
the married point. I picked up on that too, but I didn't know how to.
Well, I could actually envision the situation, it doesn't sound like it's been used, where somebody is estranged but still married and there's not divorce proceeding, how would, and one of the spouses is indigent or needs support or whatever, I could see possibly, maybe, I don't know. So.
Seems like we.
Okay, other questions, for Robin?
That's an example of that kicking the can down.
Yeah.
No judgment.
I think this can is better kicked because I think we can just take care of this,
Right, incremental change.
which I will suggest is against my personal interest perhaps as being paid as a legislator and my son going to law school soon. That this could come in handy, but I probably could not get any state's attorney to take the case. So I think it's fine. Yes, Ken,
I can't.
of course you can't.
I'm doing my best to try to understand it. But how can you just limit this? How can you just limit this to married? Because there's so many, what do you call it, significant others that are tied. There's so many that aren't married that have children together and all that. So how can you limit it to just married? And I mean,
That was my point, but I think Michelle explained that takes us down a whole.
well, I know it does, but you brought the bills in front of us, so you gotta do,
Fair enough.
you gotta do your job, you gotta do your due diligence. If the bill wasn't in front of me, I wouldn't know anything about it. Which, quite frankly, probably wouldn't have bothered me because we got other things that we
Right, and that's why I
got
don't
a lot
want
more to deal with.
That's why I don't want to open up.
Well, you already have, it's in front of us. We're on board.
No, we haven't. What's in front of us is the struck out language. We don't have to, we look at bills that there's any number of places we can muck around with and usually don't. So, I mean, it's really just dealing with the parents at this point. I mean, and letting this lie seems fine because it's not being used anyway.
I think.
But deleting and getting rid of it, the whole thing, we would need to bring in more witnesses. But it would broaden this discussion pretty significantly.
Seems like there's a remedy for any possible scenario in there civilly, one way or another. To me,
There's already remedies out there. We don't.
right, I mean,
That's what I was gonna make sure, double check our understanding that, the situation that Representative Ghostland is worried about, I think, if I'm understanding you correctly, that if, it's, the couple is not married and they have children and one, member of that couple, or former couple, what have you, is no longer paying child support, supporting the child, or even, it would be the child in particular, there is recourse already, civil
Yes.
recourse. What this statute
Well,
is.
there is.
Oh, yes,
Yeah,
yes.
yeah,
I don't know the stats, but a significant portion of our caseload involve folks that were never married and have children. So, yeah, rest assured, we're on top of that. Yeah.
This is just a criminal.
Yeah.
Okay, thank you. I can sleep tonight.
Okay.
Yeah.
So
All these are being taken care of.
that's good. Excellent. And I know OCS does a really good job, having lost a case today a number of years ago. So. Anyway, all right. So thank you. I guess that is everything we need. Do we need to hear from anybody else? I have reached out to Tim and Kim. We don't see a need to weigh in, given that the Office of Child Support is deemed to be the presumptive lead to prosecute these matters. So we don't need to hear from them. I don't think there's anybody else we need to hear from on this, unless somebody wants to suggest somebody. Do we need anybody? Anybody? Coach? So I have this scheduled for a vote on Tuesday afternoon as well. So, and so people can think about it over the weekend and see if they are in fact ready to vote Tuesday, despite it being against my interest. That's okay. Thank you very much, Robin. It was nice to see you.
Thank you. Thank you very much.
So we are adjourned, just at 1:30.